going to get that started now. And on top of that, if you have questions, please do put those in the chat. We will try to answer as best we can. We won't be able to really deal with case-specific scenarios. So please keep, personal information limited. I mean, if you've got a general question, of course, we can try to answer that as best we can. But there might be instances where it's too case specific and we won't really be able to advise on that. On top of that, I just kind of wanted to get started by introducing a few of our staff who are here with us right now. I believe I've got several of the team members. Trong, would you like to introduce yourself?
Sure. Hi, everyone. My name is Trong Nguyen. I am the Associate Director of the office.
Great. And then Katie Grace?
Katie Grace, I'm an International Student Advisor.
Perfect. And I think Nadine was trying to get on, but she may be still getting logged on. We were using the same login information, and so it kicked me off, and then I kicked her off, and so she will be joining us shortly. And then, of course, our main presenters today, we have Carol Armstrong with us from Armstrong Law. Carol, are you with us?
I am. Good afternoon.
Excellent. Thank you. So one of the things I wanted to kind of start off with, and I'm going to do a share screen here, and then we'll get started with the presentation itself. But I wanted to talk a little bit with you about kind of, as a student, a few things to be aware of. One of the things that I think is important for you as international students, F1 students, the majority of you are on F1 visas. Some of you might be on J1 visas, is to think about things in terms of when you're completing your degree. So you may all know our office pretty well because we worked with you to help you get your visa to come to the United States and study at the university. And we often talk about work authorizations and things like that. And it is a huge thing for anyone on a student visa to be able to have that work eligibility at the end of their program. But timing is often critical, and I know that we're going to talk a little bit about that, I think, in the very first of the slides here. But I wanted to just kind of point out the section of our website where you can find this information. So when you go to International Student and Scholar Services main page right here, and this is the lovely team, we're going to have a better photograph pretty soon. In the current student section, you're going to find some important information. So if you drop down to current students here from the drop down menu, or even if you scroll down on the main page and you go to the current student section, you're going to find a number of things, which includes information about student employment. But more importantly for me, I point to people to our final semester checklist. The final semester checklist is just, it brings a few things together in a simplified way to have you begin thinking about your final semester at the university. So for some of you right now, you're just starting your journey with us. You've got a few years left to complete your degree. So the final semester is not something really on your horizon. For some of you, though, you might be graduating this semester or next semester, and so it's a little bit more urgent. So when we talk about this, we have some information on our website about enrollment in your last semester, employment in your last semester, your grace period, and what you're allowed to do. So if you go down to the enrollment and past that to the employment section, we talk a lot about, for F1 students, optional practical training. That's going to take you to a section on our website where we have all the information about applying for optional practical training. And for those of you who are on J1 visas, academic training. Now, we don't have nearly as many J1 visa holders studying at the university, but academic training is the equivalent of the optional practical training. It's handled in much of the same way, but the end result might look a little different. The other things that we talk about in here are things like grace period. So at the end of your program, you have a short program, a grace period to apply for optional practical training or academic training. So we want you to think about this and use this page as kind of a guide for this. It is actually on the rotating slides on our front page. If you see this lovely woman here that's asking if you're graduating, if you click into that, it will take you to our final semester page, and you can easily read up on these things and then get a little bit more detail. I want you to think of our office as a good resource for you because we know that you have a lot of questions. And let me see, I have to expand my window a little bit to see who all's on the call. Did we have Nadine be able to join us again? Let's see. Yeah, here she is. I'm going to make her a co-host as well so she can introduce herself. Yes. Okay. Nadine, would you like to introduce yourself and just say a couple words?
Yes, of course. Let me redirect this camera. I don't like it looking at me. So yes, I'm Nadine Cal. So I am the advisor helping mostly with work authorizations. So I do a lot of OPTs and CPTs all day long. So if you have any questions, any concerns, just reach out to me. Also, what did I want to say? If you are getting close to your final semester, please set up an appointment with me and we can discuss what your next steps are and what needs to be done when, so that we're doing everything in a timely manner.
Excellent. Thank you. And so with that, the main reason everybody is here today is actually to hear from Carol. So Carol, I'm going to get your slideshow going here and share screen. And that way you can talk to us about all the different ways to get to green cards and work visas and everything else. We greatly appreciate you being here. For all the students here, just for context, Carol Armstrong she runs Armstrong Immigration here in town, and they do all the immigration work for green cards for international faculty and staff here at the University of Alabama.
Good afternoon, everyone. I'm happy to be with you, and I'm hoping that between me and Charter, we can provide you with some information that's helpful in planning for life after graduation. We're going to talk about a lot of different options as far as, what do you do first? What do you have to think about? Where are the traps and, things where you can failure to plan can get you in trouble. And I hope that the one thing that I want you to take away from this is always be planning ahead. Don't wait until the last minute. Find out what your deadlines are well in advance and plan to, get things submitted as soon as possible. Because if you don't, you're going to be in a situation where you can't file for a benefit, or you're going to have to take a more a lengthier route, maybe have to consular process as opposed to just being able to get things changed or adjusted here in the United States. The very first slide here, we're going to talk about OPT, and Charter's already talked about that a little bit. Just want to make sure that you understand that OPT it has a finite term to it. So, you may have, as you complete a degree field, then you are eligible for between 1 year and 3 years, depending on your field of study. The STEM disciplines, they will get a total of 3 years. I know within Charter's office, they do really well with making sure you guys know all of your deadlines and reminding you about when you need to do things. But maybe Charter just kind of point out the key points about when can I file for OPT and how much is it going to cost and how long does it take for me to get my work permit?
That's a good question. Actually, you asking me when you said the fee, I was like, I don't remember what the current dollar amount is for an I-765. It's been a little bit. So I'm going to defer to Nadine on that. Timelines, I know. The current rate, I can't remember off the top of my head.
All right, so really, and that's what I was touching on earlier. The first thing we need you to do is submit your final semester notification either at the end of the semester before your final semester or at the very beginning of your final semester. This is because your whole OPT timeline is based on your completion date, which is based on when your final semester is. Okay, so once we have determined what your completion date is, you can file the I-765 with USCIS starting 90 days before your completion date. So let me give you an example. If a spring is going to be your final semester, spring 2025, then you will graduate in most likely, okay, your program end date will be early May. And then you will be able to file for OPT starting mid-February, early to mid-February. So that's kind of the timeline. You can start filing 90 days before your completion date. You can still file during the 60-day grace period, which is the 60 days after your completion date. And when you file for OPT, you have to request a start date for your work authorization. And that start date that you're requesting has to be also during the 60-day grace period. So the 60 days after your completion date. Just so that you're aware, right now, and I was discussing this with Strong and Shorter yesterday, I think the processing times for OPT are about 4 months. So that means from the time you file the I-765 with USCIS until you get your card, it's a good 4 months. You are not allowed to work until you've received your EAD card and until the start date listed on the EAD card. So most of the time students get the start date they requested, but depending on a few things, you may get a later start date. But it is, on our end, it's a quick process, but on USCIS end, it's a long process. So think of it ahead of time. Just file early is my best advice. File as early as you can. There is an option to file with premium processing, but okay, the cost for regular OPT application is $470. If you add premium processing, it's an extra almost $1,700. It's $1,685. So that's a big difference in cost. I think that's about it.
And
So, go ahead, Charlie.
oh yeah, I was just going to say premium processing is a lot of money. But for those of you who have very short timelines to get an approval of your OPT, because you're graduating, even if you plan early, but you just need to secure that card on time, sometimes premium processing is the only option. Nadine's usually has those conversations with you. So if you have questions about it, you know, the timelines and the processing times do shift month to month and even week to week sometimes. So we can give you a better sense of what we're seeing. You know, we don't want anybody to spend unnecessary money, to be honest, for this work benefit. But if you're in a tight situation, that premium processing gets you an answer. How quickly, Nadine? Usually.
Well, they guarantee an answer within 30 days, which means that typically you should get your card within about 6 weeks. But honestly, what I've seen is that they've been processing those faster than that. And usually within 10, 15 days, they are approved. And then we actually get the card within a month. But once again, what they guarantee is actually adjudication of the case within 30 days. So you could be waiting for your card for 6 weeks, about 6 weeks.
Better than 4 months. So
Better than 4 months, yes.
all right.
Well, and the big picture to take away from that as far as planning goes, if you have secured a position with the company and they want to get you started, 1 week after graduation, then if you're just filing around graduation or shortly before, and you're looking at 4 to 5 months before you're going to have your card, you may lose a job opportunity because of that. So that is just another one of those reasons to plan early, file early. If it's, absolutely you have to have that card in hand by date certain, then you may just have to spend that money for premium processing so that you can get that kind of guaranteed date of getting your card.
And you don't need to have a job offer when you're filing for OPT. OPT is an authorization for you to work in your field, but it's not linked to a specific employment.
Well, Nadine, let me ask you a question. What happens, I get a job, or maybe let's say I don't find a job for whatever reason. I've got my OPT card, but I'm just having a hard time in my field finding a position. But is that gonna harm me in any way? Am I gonna lose my right to work?
Eventually, yes, but during your OPT period, so during the 1 year period that's listed on the EAD card, you're eligible for 90 days of unemployment. So that means that basically you have 90 days from the start date of your OPT to start working and report this employment. Now, if you find an employment faster, that's great. Let's say it takes you a month after the start date of your EAD card to start working. So you've used about 30 days of unemployment, great. You work for 6 months, and then for whatever reason you're without work again, you have 60 days left of unemployment to use. So you have 60 days to find another job. Now, if you use all these 90 days, it means that you're not maintaining status, which means that probably the best idea is to leave the US. In any case, you won't be able to apply for a STEM extension, for example, or a change of status in the US.
That's good news to have. Suppose I have this job and I'm enjoying it, and I've been working there for about 8 months since graduation, and I need to go back to my home country and spend 30 days at home. My employer's going to let me be off for that period of time because I have a sick relative. Am I going to be okay to travel while I have OPT? Am I going to be able to get back in with my F visa?
Yes, absolutely. You can travel while you're on OPT. So we have a list of documents we recommend you travel with, including your work authorization card, an updated I-20 with a fresh travel signature. We highly recommend that you have the job offer with you. I would say basically anything that shows that you're re-entering the US in status, that you have a work authorization that allows you to work and financially support yourself, and that you actually have a job that pays to support you. I think that helps a lot when you're re-entering the US. Basically, they want to see that you're allowed to be here and that you will be able to financially support yourself. So if you have unpaid employment, I would say any financial statement showing that you have a good cushion will be beneficial.
Okay. On the next slide, we figure out, okay, we talked about this 1 year versus 3 years perhaps that you have this OPT status. It's going to run out. And so this goes back to the general theme. You're going to have to plan for what's next. And there are several types of temporary types of status that for which you get work authorization. And one of the more popular ones is the H-1B. Now, the H-1B is a petition for H-1B status, and that is a specialty occupation. So a specialty occupation is a position that requires a minimum of a bachelor's degree in a particular field of study. So if you have an accounting degree and you're going to work as, entry-level accountant, yes, that's going to qualify for an H-1B. However, if you have a general management degree and you're going into a field where you're going to be working, doing financial statistics, that's not going to qualify because your degree, number one, if that particular job, if you could have an array of different types of degrees to be able to do that job, it's not going to qualify. So in the grand scheme of things, if you're looking at possibly changing status after OPT to an H-1B, you got to think about the type of position that you're looking for just to make sure that the position itself is going to qualify for an H-1B. There are also a lot of other issues relating to these H-1Bs that impact your planning. There are cap subject employers and there are cap exempt employers. And the whole story of that is there are only 85,000 new H-1Bs available each year if your employer is subject to that annual cap. And most of your private companies are going to be subject to the cap. Charter, can you think of any sort of organization that might be cap exempt?
Gosh, they probably are really great and might even have a football team or two. Uh, uh, Universities. So any higher education institution, whether they be a public university like the University of Alabama, a community college like Shelton State, a four-year private school like Stillman College, a for-profit institution like the University of Phoenix, online, or a not-for-profit institution, if they are determined to be an institution of higher education, specifically post-secondary after high school, they should be considered cap exempt, broadly speaking. And there are some other cap exempt organizations out there. There are like research laboratories with affiliations with universities, and government agencies, I believe, are broadly cap exempt as well. Unfortunately, K-12, for those few elementary and secondary education majors out there, high schools and elementary schools, even if they're public, are not necessarily considered cap exempt. They are often subject to the same cap.
And the reason that this is important is this comes back to your planning. So if you are subject to, if your employer is subject to the cap, that cap year begins on October the 1st. That's the beginning of the fiscal year for the US government. And the earliest that you can begin the cap subject filing process is in March of that year. So what happens is the employer submits a registration with your information in March, early March, and then there is a random selection process. We commonly refer to it as the H-1B lottery. And only the petitions that are selected out of those registrations can actually file an H-1B. And the reason that that lottery is there is because there's, as we talked about, there are 85,000 of these H-1Bs available each year. USCIS typically gets about 3 or 4 times that number of registrations. So, and 20,000 of those of those numbers, of those cap numbers, are reserved for people who obtained a U.S. master's degree. So that further limits, the other 65,000. The good news is if you are fortunate enough to be in a STEM category, you may have, 3 bites at the apple, so to speak, where you get to submit a registration in each of 3 years. So it is really important to make sure that you are getting a registration in each year of your OPT if you're on STEM, because you might not get it the first year, you might not get it the second year, you might just not get it the third year, but hopefully at least that makes your odds a little better if you're submitting registrations each year. If you only have the 1 year of OPT, you're only going to have one shot at it. And if your registration is not selected, then you're not going to be able to file an H-1B petition for that year. And you're going to have to look for other options after OPT. There's a lot of planning and coordination and, timing that goes into a cap subject filing. If you are working for a cap exempt employer like a university, then guess what? You don't have to worry about any of that stuff. You can just disregard everything that I just said, because there are no limitations on the number that are available, and there is no timing. Basically, you get hired, for example, if you were hired by the University of Alabama, Charter's office would have you come in, or work through your department to have you come in to get all the necessary paperwork and file the H-1B petition, period. And so there's not a timing issue so much on that, other than just the processing times that obviously none of us have any control over. So with the H-1B, it is employer specific and job specific. So if, let's say, University of ABC files a cap exempt petition for you for let's call it an instructor of math position, then and you find a better job paying you about 25,000 more a year with, University XYZ, you cannot take your H-1B that you got with the first university. You can go to work for that second employer, but that employer also has to file an H-1B petition for you. So that's just something, to beware of. If you're working with cap subject employers, the good news is you only have to be counted one time, which means if you go to work for ABC company and you were lucky enough to get selected in the cap registration, and then you find a better job with XYZ company, then you basically can go to work for that second employer without having to worry about these caps and, the filing timelines associated with that. The second employer does have to file a separate petition, but at least you don't have to worry about all the cap issues. An H-1B can typically, you get those for up to 3 years, and then you can renew it for another 3 years. But the maximum amount of time that you can be in H-1B status in the United States is 6 years. And that's the general rule. And so after that 6-year period, you have to leave for a year, and then you can come back in and apply for a new H-1B. If it's with a cap subject employer, you're going to be subject to that cap again. There is an exception to that rule. And generally, if you have started your permanent residency processing, then you are able to extend beyond that 6-year limit. So you can, and we'll talk about why that becomes an issue later on. But basically, if you're in a situation where you started your permanent residency processing, but you haven't completed it, you need that H-1B time, so you'll be able to extend it in most situations. All right, next slide. Next slide. There are some other temporary options, and you'll see with all of these that we're going to be talking about, it's a letter of the alphabet. So it's kind of the alphabet soup of non-immigrant status. Basically, it's just, there are different types of status that you can apply for if you qualify. So for the H-1B, for example, we said, okay, it has to be a position that requires at least a bachelor's degree in a specialized field of study. It's not that your degree is a bachelor's degree or higher in a particular field of study. It's does that job require that? And then you have to take into account, whether it's a cap subject versus cap exempt employer. There are other options out there. If you are from Mexico or Canada, we've got the TN. That basically requires that you have a professional position in the United States, and a professional position, there's a list of them, but generally those are going to be jobs requiring a bachelor's degree or higher. But if you're not from Mexico or Canada, that doesn't do you any good either. There is the O visa. That's going to be for folks who can demonstrate exceptional ability in their particular area of expertise. So that is a higher standard. And many of you won't be able to meet that just because you're just graduating and, you haven't had an opportunity to gain that exceptional ability. We've got E's for treaty traders or treaty investors. That's typically going to be where you're working for a company that has a certain level of trade between that country and the United States. And that company here in the United States has to be owned by someone from that treaty country. So we see a lot of E's with some of the German-owned companies around town. Those are frequently used for those, but either you fit that or you don't. And, a lot of you are not going to fit into that category. There's some others that are used, intra-company transferees. That's the L. You're probably not going to be eligible for those just because it requires you to have worked for an affiliate company located outside of the United States for at least 1 year of the last 3 years. And then you're coming back to the U.S. entity to perform, certain types of work, executive, managerial, specialized knowledge. But if maybe you happen to get a get a job outside of the United States where you're working for a company that has operations in the United States, and perhaps after you've been there a while, the company will be looking to transfer you back to the United States. So that would be an option. Athletes have their own type of status for which they can apply. There are new visas for victims of certain types of crimes who report the crime and cooperating in the investigation and prosecution. But either, with that, you're either a victim or you're not. And then the Bs are something that, you may be able to do some sort of temporary change of status to while you're determining what you're going to do next. But that does not give you any work authorization. That's only a temporary allowance for you to be in the United States while you're trying to get transitioned to another type of status. And I've seen that happen before with folks who are trying to maybe start a new program, a new educational program. Sometimes if you don't get enrolled in it in time, maybe you have to change to a B to give you time to complete all the steps to get you enrolled. Sometimes the Bs, you can do those temporarily while you're waiting to start maybe a TN or something like that. The good news is with the H-1Bs, the good news about those and the cap period, let's think about it. You get out of school, you get out of school in May of, let's say, 2023. And so you were, you were timely and you got an OPT, a 1 year of OPT, and it is going to expire in May of 2024. Well, Carol, I thought you said that the start date with CAP employers is October the 1st. So what, am I going to have to leave the United States when my OPT runs out? Can I remain in the United States? I think that's a good question. What do you think, Nadine? Or Charter?
I can take it. Let me just get back on the video if it will allow me. There's a cap gap. So if you're authorized, if you've been approved for H-1B, you will be able to keep working on your F1 status until your H-1B kicks in.
So that is a great provision in the law because, the law realized that, these folks are getting kind of stuck with, and the employers are in a position where they can't keep employing this person during that cap gap period. So that is very helpful if you're going to be going into H-1B status with a cap subject employer. So that's kind of the big picture on the types of temporary status that may be available to you after you complete your OPT period. Again, it goes back to either you qualify or the position qualifies. And, are you acting in a timely manner, particularly with the H-1Bs? Do we have any questions relating specifically to the temporary options?
Nothing yet, but students, feel free to, if you do have questions, general questions, you can put those in the chat. And we'll try to tackle those as we can. Tron, Katie Grace, Nadine, and I are all looking for those.
Okay. So on the next slide, we'll start talking about, what about permanent residency? At some point, whether it's an H-1B or, an O or a TN, at some point, you're going to want to have some sort of permanent status in the United States if you're going to continue to be in the United States. And again, that goes back to planning on when you should do that. The questions that I always get is, well, how long is it going to take? How long is it from the time we start this till the time I have my green card in hand? And I'm going to give you the standard lawyer answer. Well, it depends, because it does. It depends on the category in which you're applying. It can sometimes depend on your country of birth or your spouse's country of birth as to whether or not, you're going to be in the jungle, if you will, for a year or 15 years. So it's important as part of your planning is maintaining your safety net, because to qualify to get your green card based on employment, you have to maintain an underlying valid non-immigrant status, such as an H-1B or a TN. The other thing that you have to think about is, how does this impact your travel? If you're starting a permanent residency process and you're still in F1 OPT status, you are gonna have a period of time where you're not gonna be able to travel. There are, other types of status where that will also be an issue. And you also have to think about if you have a spouse or children who are dependent on your status, how is that going to impact them? What steps do you need to take to make sure that their status is protected as well during the process? So we're going to talk about a few different processes that get you to permanent residency or green card. That's the same thing. Via employment sponsorship. There are basically 3 tracks for you to obtain permanent residency. One is based on family relationships. For example, if you are the spouse of a U.S. citizen, then you would have a family-based route to apply for permanent residency. Other route would be protection categories. That's going to be your folks who are filing for asylum, maybe some crime and trafficking victims that have an alternate route to permanent residency. And then there's employment-based permanent residency. And that is, that requires, for most of the categories, not all, but it requires that you have an employer who is willing to sponsor you. And so when you are in the course of looking at employers and thinking about, the short term and the long term, you want to make sure that the employer that you're going to be working for is going to understand the intricacies of working with a or having a foreign national employee and the sponsorship that goes along with that, either on a temporary basis or the permanent basis. So for most employers, we go through, or for most employment-based cases, we have to go through a process called labor certification. Labor certification is just a process that the U.S. Department of Labor says that the employer has to go through to test the U.S. labor market. What that means is the employer has to go through and do some advertising and recruitment, review applicants, and determine that there's not a qualified U.S. worker available to take that position. In that case, if no qualified U.S. worker applies and is willing to accept the position, then it can be offered to a foreign national for purposes of labor certification and green card processing. There are a couple of different types of processing under labor certification. There is a special type of labor certification process. It's called special handling or special processing. That is only for university teaching positions. And so if you are working for a university, then that may be an option for your employer to start your processing through the special handling. However, most of your employers are going to fall under what's called traditional recruitment or basic recruitment. That process requires the employer to place ads, and the Department of Labor is very specific about what those ads have to say and where they have to be placed and how long they have to be placed. And once the employer goes through that recruitment process and goes through the applicants, if there is not a qualified U.S. worker available to take the position, then we can get it certified for labor certification. But that's just the first step in the process. If we're doing an employment-based labor certification case, you also have to go through filing the application with the U.S. Department of Labor. And then there are other steps that are filed with the Immigration Service, including an employer petition, as well as an application to adjust status to permanent resident. Those are filed after the labor certification is approved. The kicker here is for nationals of certain countries, you can start this process, you can get through labor certification, and you can get that first petition filed at the university, that your employer would be filing on your behalf. That last step, which is called adjustment of status to permanent resident, that is going to depend on whether there is a backlog in your category or your country of birth. Typically, the countries that have this backlog are going to be China and India. So that is why it is important for foreign nationals from those 2 countries to make sure that they have a plan for maintaining that underlying temporary non-immigrant status. Next slide. This is a different category. that a lot of people pursue because you can self-petition. You don't have to have an employer to sponsor you for purposes of the national interest waiver. The waiver component of that name, that category name, just means that the government's going to waive that requirement for labor certification. So then you don't have to have an employer to sponsor you. You don't have to have, you don't have to go through this recruitment and selection process that those subject to labor certification have to do. However, you do have to show that your work, whatever your proposed endeavor is, it has both substantial merit. In other words, it's it's something that's important, and it has to have national importance. And I will tell you, under the current administration, the government has deemed that STEM fields and particular plans for what your work is going to be, your proposed endeavor, that STEM, that is deemed to be national importance. Now, that is an executive kind of policy, if you will, and so that could change. But currently, under the national interest waiver, that if you're in a STEM field, that gives you a leg up. You've also got to show that you're well positioned to advance your proposed project and proposed endeavor. And how do you do that? Well, you've got to show that, several things that you can use to show that. Have you published articles? Have you received some funding, grant funding for, from a governmental agency? Have you been invited to come and present at conferences? Have you received attention from, outside interest? Maybe there's a company that's interested in paying to further your research because it'll be helpful in their product line. And then you have to show on balance it would be beneficial to the U.S. to waive the requirement of the labor certification process. And that just basically says, look, what I can contribute to the national interest and my preparation and being able to do that is what is important for me to get the permanent residency. It's not that whether or not a qualified U.S. worker is available. So these can be very helpful. This is a very helpful category for certain types of students. One particular position that comes up in university settings are going to be your postdocs. And once you're in a postdoc position, you really aren't able to file through the traditional recruitment because it's not considered a permanent position. So sometimes petitioning under the national interest waiver may be the only option that you have at that point. You don't have to have your PhD to get a national interest waiver. I've represented folks who had masters. Typically, it's best if you have the PhD, but I have represented folks who have master's degrees, and it was a STEM field, and their work was deemed to be of such national importance that the national interest waiver was approved. Period. Any questions about labor certification or the national interest waiver?
Nothing about the national interest waiver. Somebody asked a little bit more detail about the O1 visa, and I shared the link actually, and I'll share it to everyone to the USCIS page, which actually details bullet points of like you have to meet these criteria to apply, and that's there. One question that just popped in: is a lawyer required to file a national interest waiver application?
It is not required. You are certainly going to be in a better position if you have an attorney who is experienced in preparing and filing these national interest waiver petitions. They're very difficult cases, and there's a lot of documentation and peer support letters and the like. And the way that the case is presented to the officer that's going to be looking at it is important. There are plenty of people who file on their own, but having an attorney is certainly in your best interest, but make sure you're getting someone who has experience with those national interest waiver cases.
I think that's so as someone who works in immigration but is limited to, you know, the university setting, I will say there are times where our office cannot advise, and nor can we recommend one attorney. As much as we love Carol, and as much as she does for our institution, just because a student walks in the door, we can't say go to Carol's firm for your services. We have to limit it to what, you know, we have a direct contract for and everything else. But I will always say there are some things we can advise, and we would advise an immigration attorney. And then the added caveat to that is make sure that they have a background in your specialization. Just like an immigration attorney is a specialized attorney, there are subspecializations within immigration attorneys. So you could find an immigration attorney and they might be specialized more in deportation hearings and protections and those types of cases, and not in national interest waivers. Or you might find somebody who's much more involved in the O visas and the extraordinary ability cases for those who are like athletes and musicians and artists, and they've never seen a national interest waiver case in their life. So this is, yeah, I think Carol's point, definitely make sure that the attorney that you are seeking out has a background and a specialization in national interest waiver cases.
And I mean, and a lot of attorneys will advertise on their websites is, you know, the types of cases that they handle. But an attorney should not be offended or feel imposed upon for you to say what is your experience with this type of case, because you know, I know that if I'm going to have someone do something of this importance for me, I want to make sure that he or she knows what he's doing. For example, if I needed to have surgery on my eyes, I wouldn't want somebody who usually operates on feet. I'd want to have somebody who knows how to take care of my eyes. So it's kind of the same thing. And Charter's absolutely correct. There are a lot of subspecialties, even with the specialty niche of immigration law. And it does take effort to keep up with the ever changing law and policy that is immigration law, but you've got to make sure you've got someone with the experience to do these. One thing that I've seen happen in the past is where someone says, "Oh, I can help you with it." The person is not an attorney. Now I've even seen where law students try to do it. And, that is engaging in the unauthorized practice of law. If you prepare your own, that's not. That you're advising yourself on what you need to do. But if you're doing it for someone else, then that can get you into trouble. And I know that, sharing experiences, someone saying, well, I had a national interest waiver case and here's kind of how I approached it. If you want to look at my application, that's fine. But when someone starts preparing it for you, if he or she is not an attorney, you may have some problems with that. So moving on to the other types of permanent residency processing, there are some others. And one of those is in the university context. Now, this is going to require you to have a position with a university that is a tenure or tenure track position, a teaching position, or it's a comparable research position, which means a permanent research position as opposed to just a postdoc. You also have to have 3 years of experience in either teaching or research in your area, in your field. And you have to make sure that for teaching, you must have full responsibility for the classes taught. So a teaching assistant or a research assistant position is not going to qualify toward that 3 years of experience. Now, this is something that, obviously, if you're just looking to graduate with a bachelor's or a master's, you're probably not going to be looking at this category. But for those of you with working on your PhDs that, and you are intending to go into academia, then this is absolutely something that you may want to think about. Again, outstanding professor or researcher, the Immigration Service is not concerned of whether or not there's a qualified U.S. worker out there to take the position, but rather it's all of your contributions to the field that make it fair to give you a permanent resident green card because of all of those accomplishments. you've got to be cognizant that there are certain criteria that the Immigration Service is going to be looking at, but there are certainly no set number of articles that you have to have published. There's no set number of journals for which you have to review, or no certain number of prizes or awards that you have to have. It is a very subjective category, just like the national interest waiver is a very subjective category. So it's like putting pieces of a puzzle together to get the whole. You have to be able to demonstrate international impact in your field. The Immigration Service will not accept any weak evidence to show that you qualify under those criteria, and they'll actually use it against you if you try to submit weak evidence. So again, if you're looking at this particular option in the future, you're going to want to make sure that you've got an attorney, and you're not required to have an attorney, but it is certainly in your best interest and your university's interest to make sure that you've got someone that can, review your resume and determine whether or not your case is a strong one. Next slide. That kind of concludes what we're going to talk about. There are some additional categories that deal with extraordinary ability. For example, extraordinary ability is a very, very difficult case to prove. You basically have to show that you're in the top percentage of your field, and very few are at this stage in the game when you're just graduating. There are exceptions. Some people really can meet that standard, but it's few and far between. So just keep in mind that as long as you are planning accordingly, then and making sure that you're discussing the options with your employer and planning for those. If it's a cap subject employer, making sure you're planning to get those registrations in a timely manner. It's all about, like I said, the theme is, be sure to plan ahead. So I wanted to just briefly touch on the other types of processes that are available. We talked about family relationships. If you're married to a U.S. citizen or have some other type of family-based preference, then you may be able to just go that route. And it's going to be much shorter, and it's going to be much easier than it might be to go through all of these employment-based categories. But either you have that family relationship or you don't. And if you don't, then you've got to look at other options. Next slide. There are some special categories, and this is what we talked about, the protection categories. The U status is a particular status for victims of certain types of crimes who report the crime and cooperate in the investigation and prosecution. And so what we always try to let folks know that, if that should happen to you, go get some advice from an immigration attorney who works on those types of cases, because it can be an alternative process for you to allow you to get work authorization and remain in the United States. And then there's asylum, but that you must have a credible fear of return to your home country because of some past persecution or anticipated future persecution. And what we typically see with that is when we have students who are here in the United States and then bad things happen in their home country. War, for example, is a very good example. But perhaps there's a change in, the government, and, you're somehow affiliated with the government that was overthrown, or maybe you've spoken out against the government that's in place now. So either you have that credible fear or you don't. It's going to be, it's a process, and it is a path to permanent residency. But again, you either fit the category or you don't. Those are pretty much all of the basic categories for permanent residency, as well as some of the temporary types of status. I'm happy to answer any questions that you may have. Period.
There's nothing in the chat really at the moment, but I will say among these other special categories, we've seen a real increase in the number of countries designated for, say, temporary protected status.
Yeah.
And while it hasn't necessarily impacted any major populations here at the University of Alabama, There have been a few that have, well, you know, a pool of international students from that country. So the most recent one, Lebanon, was added to the list, right? For TPS eligibility, or something akin to deferred action, like deferred enforcement of
Departed
deportation.
for departure.
Yeah.
Yeah.
So it is, you know, we've seen that happening a lot, and it hasn't necessarily led to, I don't know if you've seen increases in asylum cases from those same countries. But the TPS, in my career, I have not seen as many TPS designations as I have in the last several years, last 6 to 8 years.
Yeah, I agree. And depending on what happens in about 11 or 12 days, then, you know, some of those may go away.
Yeah.
That is the thing about temporary protected status and DACA, which is for the dreamers. Those are put in place through what's called executive action. And that is something that can be changed from one president to the next. And so that's where you'll see a lot of those things. When you see immigration policy changes, you probably won't see a lot of substantial changes in, you know, statutes which govern immigration law, because that has to come out of Congress, and they can't tie their shoes up there right now. So we're not going to get any significant immigration reform out of Congress. So the president has an enormous amount of power when it comes to immigration law and policy. The president appoints the Secretary of Homeland Security. So you've got all these various application processes that fall under U.S. Citizenship and Immigration Services. We've seen in, you know, prior administrations, seen fluctuations on the way that, you know, cases are adjudicated, with processing times for getting cases approved. And that is all because that's at the instruction of the Department of Homeland Security. The president also appoints the Secretary of Labor. So that can have impact on, we were talking about labor certification processing, and that can have an impact there, particularly in staffing and processing times. And then one of the big ones is the president appoints the Attorney General. And the Attorney General is the head of the Department of Justice, and the immigration courts and the Board of Immigration Appeal fall under the Department of Justice. So the Attorney General has enormous power in setting the case law as well as policies for cases that are in immigration court. So that's why I come back and say that there is an enormous amount of power in the executive branch with respect to immigration law. And you probably, you know, if you watch TV at all, or listen to the radio, or get on social media, or just walk down the street, you're going to hear things about changes in immigration policy. And, you know, that's all they're talking about now in the debates on who's going to, you know, win the presidency. And asylum, there have been a lot of changes in, you know, the way asylum cases are handled at the border, and people being turned back if they're coming in trying to apply for asylum. So there's a lot of power in that. And that's why we always begin and end these sessions by saying, this is the law right now. I can't promise you tomorrow that this will be a law because there are, you know, it's an ever-changing field. But at least with this presentation, you at least get some idea about the resources that you got through Charter's office and through the university's website, all the information that is there. And then, you know, kind of have a big picture on the types of immigration processes that may be available to you.
So one of the things too, and I know you have these caveats here, and it actually, I have a direct message here, and it's a question, but it's a question that really should be answered to the entire group. Are F1 students allowed to apply for the diversity visa lottery? That is another path towards permanent residency. And so the DV lottery is currently open. It's supposed to close in about another week. And so I don't know if you have very many clients that actually go through the diversity visa lottery process. Usually that's kind of self-petitioned. I've seen a lot, but
Yeah, typically folks who, you know, enroll in that lottery or apply through that lottery are doing so on their own, because there's not a whole lot that's required as far as submitting that registration. Where we typically is get involved as attorneys is when the person actually is selected in the lottery, and then they need assistance with either the consular processing to come to the United States, or if they're here in the United States, to apply to get their green card based on that diversity visa lottery. But if your country qualifies for that diversity visa lottery, it's certainly another path. There's no guarantees with it. But if you are lucky enough to be selected, then you don't have to worry about all these other processes. You can just go straight to, what do they say? Go straight to Pasco and collect $200 as a monopoly game stakes. But that is an alternative. My understanding is that as an F1, that is not necessarily demonstrating immigrant intent by simply in registering for that. However, if you are selected, at that point, you've got an issue with traveling. So that's one of the things we point out here. The laughing hyenas, if you will, the potholes is going to be travel issues, and making sure when you're traveling, making sure that you're going to get back in.
Yeah. So, and I will say this, our official stance on this to everybody here on the call and who might be tuning into this later is we strongly encourage everyone to maintain their underlying visa status throughout their green card process. The green card process is obviously a long one. It starts with someone sponsoring you, whether it's you filing on your own, or your employer filing, or a spouse or family member filing, but someone has to initiate the case, and then it's later before you're able to file for the adjustment of status, which is actually the green card application. So there's all the stuff that leads up to that, but none of that grants you any ability to remain in the U.S. At all. It's only the actual I-485 that grants you that ability to stay. And so even once the I-485 is filed, we still recommend someone to maintain their underlying visa status, if only because there is always the chance that your case could be denied. There could be something that delays it without any really rhyme or reason, maybe a shift in administrations or a shift in policy. If you have abandoned your underlying visa status while you're going through the green card process and your green card case is ended, then you have nothing to fall back on necessarily. So having that underlying visa status, so it's perfectly legal within the U.S. to go through the permanent residency process as an F1 or a J1 student, for instance. But keep in mind exactly what she's talking about with travel issues. F1 and J1 visas are non-immigrant visas, and you cannot travel freely internationally while your green card case is in any stage of pending without having basically violated the non-immigrant requirements of your visa. So it's perfectly legal to do it while you're in the U.S., but if you travel, getting a renewal of your visa, getting back into the U.S. becomes really impossible if you don't have, if you're not at a later stage of your green card that you have a travel authorization with that. So be really careful. So when you reach out to us and you ask, can I do this? I'm going to say yes, but with a caveat, please, be aware of these things. And we strongly recommend you work with, attorneys, or, let us know, blah, blah, blah. So just keep these things in mind, maintain your underlying visa status. The worst thing in the world, and I've seen this happen, I've had someone at this institution do this. They filed on their own through the national interest waiver. They got their EAD card. They decided to abandon their work visa with us. They decided we don't need you anymore, University of Alabama. And they were working, and their case was denied, and their H-1B didn't exist anymore, and they had to leave the country. We filed a new H-1B for them, and we had to then wait for them to get a new visa and get back. They were out of the country for 4 months. This is an employee that could have easily just let us extend their H-1B, but they insisted that my EAD card is good. I don't need you anymore. And so this is an instance where, like, that is my big example. Like, you don't understand the disruption to your life that could happen if you abandon your underlying visa status. So anyway, I'll get off my soapbox, as they say. I'll quit preaching to everybody. We like to be cautious in our advising and make sure that people have backup plans for what they're going to do next.
Oh, absolutely. I think that's very important. One pothole that I did not list here that warrants mentioning is one thing you got to take into consideration in your planning and your filing is renewing your driver's license. That is problematic because timing and, while things are pending and if your license is expired, are you going to be able to, renew it for any period of time? And so that's something you got to think about. I will tell you that the Department of Motor Vehicles, you may ask a question today with this officer and get an answer, and then later today or tomorrow morning, ask it with that same officer and get a different answer, or ask it with a different officer and get a different answer. So they can be difficult. Some of them don't understand dealing with foreign nationals and the intricacies of the processes and what a receipt notice is and so just aware that you need to take that into consideration as well. Any other questions?
I don't see anything in the chat at the moment. I do want to make sure to get to the your contact information here. I will say, students, if you have questions, we have students who go through the green card process while they are students. That does happen. One thing is, I will say, if you have a change of status while you're here as a student, if anything impacts your F1 status, please do let us know. We're not trying to be nosy. We want to cheer with you when you get your green card too. But the reason for that is that it impacts your F1 status. I've had so many students who assume that I knew that they got their green card. I'm like, well, why would I know you have your green card? Like, nobody tells me, unless you tell me yourself. The reason I don't mean to laugh, but they think that all the government agencies talk to each other in a way that we're all notified at the same time of whatever happens. The only people that notify you what's going on a minute by minute basis are Amazon and like Domino's pizza delivery. Everybody else, you're on your own. And so you do need to let us know. I have a section, and I put it in the chat, about for current students about extensions of stay and changes of status. And it's a section on after your green card. And that section is really to say, notify us, give us a copy of your green card so that we can then make sure your SEVIS record has been ended appropriately. You'd be surprised how many people's F1 records are still just cooking along. And as long as you keep enrolling full time, we're going to continue to click registration every semester and keep that F1 record active until you tell us. And I've had some folks, a year goes by and they've been a green card holder, and we've continued to keep their F1 records active. And then they have problems at the DMV because the DMV is pinging back like lots of different records that are simultaneously active. Also, if you happen to get US citizenship, we will not know unless you let us know. So we would need a copy of your naturalization paperwork so that we can update our system and the UA system so that you properly are reflected as a US citizen. And just be aware that once you become a permanent resident, our office really can't offer visa support or anything, but that section that we have has a couple of links back to like USCIS pages about travel as a green card holder, work as a green card holder, extending or renewing your card as a green card holder, things like that. So, it's there as general information. We're very limited on what we can provide you as assistance. But we do want to just, know that you do have a little bit of a support network there. So. And then I think that's it. If anybody else has any questions, feel free to drop it in the chat. But I've really appreciated Carol and my team here with Trong and Katie Grace and Nadine being available. And I want to just say thank you to everybody who was able to join us today. I know that Carol's on a bit of a tight schedule. So she's got something right after this. So I want to be mindful of our time with her. But if there are no other questions, I think we can stop share and say goodbye.
All right.
Y'all have a good day, everybody.
Thank you.